Hi, everyone. Thank you for joining today's webinar presentation, Patent Prosecution Analytics, no longer just a nice to have. I'm Allie Morton, Head of Field Marketing at LexisNexis IP, and we have a really exciting and informative webinar planned for you today. But first, we just need to cover a couple housekeeping things. During the webinar, please feel free to submit questions using the question feature in the control panel. Also in the control panel there, you will see a handout section. This is where you can access the webinar slides from today's presentation, as well as collateral sheets about the Patent Advisor product. A follow-up email of the recording from today's presentation, along with the slides, will be sent to you later today. Now, I would like to introduce our presenter, Megan McLaughlin, Product Director for LexisNexis Patent Advisor and Patent Optimizer here at LexisNexis IP. After graduating from Harvard Law, she worked as a patent attorney at the law firm of Nutter, McLennan and Fish. Her technical focus reached into a variety of industries, including medical devices, the food industry, software, printers, biotech, and more. I'd like to thank everyone again for joining today's presentation. And with that, I will turn it over to you, Megan.
Thanks, Allie. Can you guys hear me? Can you hear me okay, Allie?
Yep.
All right. So thank you everyone for joining today. Like Allie said, I used to be a patent attorney, but for 6 years now, I've been working with LexisNexis on building out our prosecution analytics products, specifically Patent Advisor and Patent Optimizer. And the reason that I wanted to talk to you guys today is that I've noticed a shift in the industry over the past couple of years. So when I first started with the company, this was back in 2015, I used to hear a lot of objections to prosecution analytics. You know, I've been doing this for 30 years. I don't need the numbers to tell me what I need, what to do next. Or I know all my examiners. Why would I look at examiner statistics? But I have to say, it's been at least 3 years since I heard an objection like that anymore. So pre-COVID, different world. Now, I don't hear anymore that there's not a need for them. And while I'd like to think it's just because we made these products so amazing and irresistible, really what I think it is that two things have happened. You know, the first is that the statistics have been around for long enough that people realize maybe they didn't know everything that they thought that they did, right? Even if you've worked with a particular examiner 100 times, that examiner's probably been there for 10 years and they've worked with other people 1,000 times. And there may be something someone else did that you weren't aware of that's actually really successful. So the first is, you know, maybe we weren't the experts that we thought we were on this issue. But the second, and I think the most important reason that I don't hear this objection anymore, is that people are realizing that prosecution analytics helps to get everyone on the same page. It helps to set expectations, right? Like, you may know that appeal is the direction you need to go in this case with this examiner, but your client doesn't know. And maybe your client doesn't like to pay for appeals. Or you may know that the part of the portfolio you're managing isn't doing well at the USPTO because it got assigned to some really tough examiners, but your boss doesn't know that. So today I want to talk about how to use this data to keep your work relationships running smoothly, to keep everyone on the same page. That's really why I think it's so important. So I'll talk about some of the basics at the beginning. So, you know, how to accurately predict prosecution outcomes, how to communicate your performance, your prosecution performance. And then I'll go into some very tactical advice on how to use the data with some of the new features that we've built into the Patent Advisor tool. All right, so starting off with the very basics, just predicting what's going to happen in prosecution. This is probably the most important thing we can do with prosecution analytics, just to help our clients and colleagues understand what the process is going to look like for them. Are they going to get a patent? How long is it going to take? And the beauty about being a patent professional is that you do have a little bit of a crystal ball, because I don't think I have to tell anyone in this room that you can go a long way towards predicting prosecution outcomes just by knowing what examiner you've been assigned to. We're lucky as patent practitioners. You know, most litigators can't say the same thing for their clients, but we do have a pretty good idea. I think the only place where I still hear some misconceptions are about what this variability actually looks like. So I think most people assume that, and this is true of the patent office, but I think most people assume for every art unit right? There's some distribution of examiners. The vast majority are average, right? 1.7 office actions per case. And then there are very few who are just super permissive, who let everything through. And then there are very few who are just incredibly difficult and don't allow anything. And if you assume that this is the case for any given art unit, then you're probably going to act the chances are you're going to end up with the average examiner most of the time. So you probably just take the same tactics most of the time. But the reality is that there are these different kinds of examiners, and in every technology space at the patent office, but their distribution varies pretty significantly depending on the technology space that you're in. And sometimes it's not as clear-cut as you think, right? Everybody knows that software is going to have examiners who tend to be more difficult because that's just the state of the law in software. But when you really dig into the data, there are surprises. This is my favorite example, 2811 and 2812, same title. I don't know anything about semiconductors, so I cannot really tell you what is different between these two. I'm sure there's something important. They have the same title. They're right next to each other, so they can't be that different. And yet one of them has almost a perfectly average distribution of fast, average, and slow examiners, and one has almost entirely fast examiners. So if you didn't know this, you're probably going to make very different decisions than if you did. And why does this matter? Because this affects everyone. So this is an analysis that I did just for one particularly large filer at the US Patent Office, but I can and pretty much have done this analysis for every major file at the US Patent Office. And the picture that it paints is the same every time. So if you divide their portfolio into those applications with what I'll call permissive examiners, and I'll explain what I mean by that in a minute, and applications with difficult examiners, you see a very distinct divide. The allowance rate is almost double for the permissive examiners. The time to allowance cut down by a year, office actions cut in half. And you can imagine for a company with this size of portfolio, the cost implications of this. So later I'll talk about how you can try to change the course of these applications on the right-hand side. But for now, the important point is that for every case on the right-hand side, you could have known that you were facing a tough situation from the minute that you got your first office action. That was completely predictable. And how do I know this? Because these applications are all coming from the same company. They're largely coming from the same set of very, very high-performing law firms. These applications are, this is not a company that's going to be filing junk applications. And yet you still see this divide, proving that who your examiner is really impacts prosecution. So if we believe that predicting prosecution outcomes comes down in a large part to knowing who your examiner is, it becomes crucial to be able to measure the examiner's behavior appropriately. Now, probably most people out there today are still relying primarily on allowance rate. It can be defined in a variety of ways. So I'll use this definition for an example: patented cases divided by patented plus abandoned cases. This is a very, very common metric. We at Patent Advisor have tried to move away from this because we realize that it has some pretty distinct, pretty serious problems with it. First of all, it doesn't incorporate pending applications. So if you have an examiner, particularly a new examiner that's got a large docket, and by the way, we do see even new examiners having dockets of between 80 and 100 applications at one time. It could take a while for them to churn through that 80 to 100 applications to have any dispositions at all. And that's not measured in allowance rate. It penalizes the examiner for abandonments. And sure, sometimes an abandonment happens because the examiner was just too difficult and you had to give up. But if I had to guess, I'd say a lot of time, if not the majority of the time, an abandonment happens because it wasn't a strategic business goal anymore, or someone just decided they didn't want to pay. So this metric has problems. So that's why in Patent Advisor, we instead rely on a metric that we call ETA, which stands for examiner time allocation. Simply put, it is the total number of office actions that the examiner issues over their career divided by the total number of allowances that they'd issue. And the premise was we wanted to measure examiners by what they do, no one else. So when the examiner comes into their office every day and they sit down at their desk and they got a pile of applications sitting there, they pick one up, they reject it, they pick another one up, they reject it, they pick a third one up and they allow it, that would be an ETA of 2. We wanted to try and measure them by what they're actually doing, which is either granting allowances or issuing rejections. And by the way, we didn't completely pull this out of a hat. This is based on some significant academic work done by Professor Shine Tu at the University of West Virginia. You can link to one of his papers there. I believe he calls this metric ogre. But we really do find that it is the singular, most helpful and useful metric to understand what's going to happen in your case. It accounts for the pending portfolio because all the office actions and pending cases are included in there. Doesn't directly penalize for abandonment. And it can be helpful for an examiner, within the first few months of their being at the office. So based on this paper from Dr. Tu, we divided the ETA categories into green, red, and yellow. Basically, if the ETA is low, below 2.5, it's in the green zone, meaning that these examiners are issuing a lot of allowances, not quite as many rejections. The yellow zone is average, 2.5 to 6, and the red zone goes from 6 to 99. We arbitrarily cut it off at 99 because, true story, some examiners actually have ETAs over 99, where they issue more than 100 office actions per allowance. But we figured after that point, you kind of get the picture. So we find that this metric is much more helpful. And you're probably thinking, well, they're going to be the same, right? ETA and allowance rate, if by definition, if you're issuing a lot of rejections, there's not going to be a high allowance rate. And if you're not issuing a lot of rejections, there is. And for the most part, that's true. So this is ETA plotted against the allowance rate for every examiner at the patent office. So each of these little dots is an examiner. And yeah, for sure, they track each other. Especially at the extremes, it's really hard not to have a high allowance rate if your ETA is low. But I particularly want to point out this middle zone. So for an ETA of about 4, you can have an allowance rate anywhere from 10 to over 90%. So if you were just looking at allowance rates, you would completely miss this. If you saw this person with a 90% allowance rate, you'd think that you struck gold. This is going to be super, super easy examiner. But really, that's not the case. Something's hidden. Maybe they're brand new. Maybe they just have a lot of churn. We highly recommend relying on ETA as an accurate indicator of what's going to happen in prosecution. And again, maybe you already have some kind of feel for this. If you've been practicing for a while, especially in the same place, you probably do have a feel for it. But one, maybe your feel for it isn't as accurate as you think. And two, the other stakeholders don't have a feel for it. They don't know if prosecution is going on because you just didn't do a good job writing the patent. This helps you to get on the same page with everyone, set budget expectations for cases, so you can know right at the beginning, the first time you get an office action, whether prosecution is likely to be fast, slow, or average. So the next thing I'll talk about is measuring your own prosecution performance as a law firm or as a corporation. And as with measuring examiner behavior, as with any kind of statistical data, you can make the data say what you want. So I think it's important that we talk about the right way or the best way, best practices for actually measuring law firm and corporate performance. So in light of what we just talked about with examiner behavior, I think any good metric for a law firm or a corporation has to take that into account. It has to be benchmarked somehow against averages for the examiner that law firm or that corporation is going up against, or it could be very misleading, especially for smaller data sets. Someone could get really bad luck, have an entire patent family assigned to an examiner who never allows anything, and it's going to make their performance look unnecessarily bad. So just as an example of that, this is an example application. This is from the timeline view in QuickPair from Patent Advisor. So this just shows, it's a visual depiction of what happened in the case. So this exemplary case was filed in 2016, about a year and a half till we got the first office action. There were overall 3 office actions and an RCE in there somewhere. And then it was issued. So depending on the examiner you got, this could be anywhere from a stellar prosecution outcome to a really subpar prosecution outcome. It completely depends on what examiner it was assigned to. If this had gotten assigned to examiner A, who allows almost everything and does it without anyone having to file an RCE, then I'd say this is not a good outcome. Whereas if it were assigned to examiner B, who almost doesn't allow anything, takes at least 1 RCE, then this would be an excellent outcome. So just like we had to create ETA to understand examiner behavior, we created the Patent Advisor Efficiency Score to help people understand law firm and corporate prosecution performance. So I actually hate allowance rate for measuring law firms even more than I hate it for measuring examiners, because really abandonments are just, they're almost never the law firm's fault, right? I had so many cases where I would be told to abandon even though I thought it was a stellar case and things were going great. And I had other cases where like I knew they should have been abandoned, but I was told to keep pushing on. So it penalizes for abandonments, which I don't like. And as I mentioned earlier, it doesn't account for examiner variability. So it can make people look unnecessarily good or unnecessarily bad. So we created this score called the Patent Advisor Efficiency Score. And really what it measures is how quickly you're able to bring the case to resolution, either patenting or either issuance or abandonment, relative to that examiner's average. So it's normalized for examiner difficulty, and there's no penalty for abandonment. The only thing that we're measuring is how quickly you were able to bring that case to an abandonment. And it's set on a scale of 0 to 100. So 50 is average. Anything below that is below average. Anything above that is above average. And I'll tell you, the vast majority of law firms have efficiency scores in like the 40 to 60 range. Most people are, it's very, very heavily skewed towards the center, which, I think makes sense, because I do think a lot of the variability and outcomes at the patent office is driven by examiners, not the law firms. I think we all know what it takes to get into a patent law firm, and most people there are very, very intelligent and driven and capable. So I want to take a break at this point and ask a poll question. So now that we've gotten to this point, we've talked a little bit about examiner analytics. I just want to know from our audience, how often you are utilizing examiner analytics in your workflow at this point. I'll give it one more minute. All right, I think it's kind of steadying out. All right, so I'm guessing you guys can see the results right now. It looks like about half of you aren't using them yet. So hopefully I can use today's talk to convince you that they're crucial to keeping things in prosecution world running smoothly. A lot of you are using it when you get stuck. So prosecution isn't going the way you expected, so you want to check on the data and see what it is. But 20% of you are using it most of the time, hopefully to set expectations from the beginning, which is great. Okay. So we have this examiner variability. We know this is the case. So when we measure our law firm or corporate performance, we have to take that into account. So this is just an example of how we calculate the Patent Advisor Efficiency Score. What we do is we actually take every application in the law firm or corporation's portfolio, and we give it a score from 0 to 100. And we base it on what's par. I don't golf, so this is a terrible analogy for me to use, but I'll go with it anyway. What's average for that examiner? So say for this case, that this is a tough examiner. ETA of 10 means they're issuing 10 rejections for every allowance. This is a tough examiner. So average for them is 3.5 office actions and 1 RCE for a patented case. So we expect prosecution to be a little bit rough. This exemplary case, however, went way above that average. Right, 4 RCEs, 9 office actions, and no judgment. I don't know what happened in this case, but we will say that this is probably not what any of us want when we go into prosecution. So this case would get a score below 50. And then what we do is we take all of those scores and we average them. So we take the score of every application in the data set, we take an average of it. We give an overall score, and then we provide scores for just the red examiners, just the yellow examiners, and just the green examiners. So you can have an idea of how your firm or corporation performs in front of that group of examiners. And we did this on purpose because when we started calculating these on a large scale, what we realized is the green scores are all very, very close to 50, because with these kinds of examiners, granting patents and doing it quickly is kind of their job, like what they do. So it's almost hard to not get a quick resolution with them. It's hard to deviate. It's uncommon to deviate from the average. Yellow score about the same. It's with the red examiners, those ones who have an ETA above 6, those ones who issue a lot of rejections per allowance. This is where you see a lot of the variability. And this, by the way, is where is probably, to me, the best measure of a good patent practitioner. If you're a patent practitioner who consistently gets good and efficient results from red examiners, to me, that's the measure of a good patent practitioner. And let me just give you an example of why it's so important to normalize for examiner variability like we do with the efficiency score. So I took here group 2120, which is the art unit for AI. AI is in a lot of places in the patent office. In fact, I might go so far as to say it's in every technology center, but this is a technology center group that actually is titled AI, so I'm guessing most of them end up going here. So if you divide the top, I believe I took the top 10 applicants from the USA, the top 10 from Europe, and the top 10 from Asia. And what this chart is showing is the USA is above average in terms of both effectiveness, so how many patents are they getting, what's their allowance rate, and efficiency. And we're measuring efficiency here in just time to allowance in months. Right? So the green zone is above average, the red zone is below average. So USA is kind of the leader overall. Asia is the leader here in terms of efficiency, but their allowance rate's a little lower. And Europe over here is in the red zone for both. And by the way, I will say, and this is common, it is a little bit of a situation of sometimes you sacrifice one for the other, allowance rate versus time. But overall, this is kind of what the competitive situation looks like in this space for the top 10 filers from each of these geographies. But now let me change this x-axis here from just an objective raw metric, time to allowance, to the patent advisor efficiency score. So I'm going to take examiner variability out of the equation here and watch how things just shifted. So the USA moved way over here. They're not above average anymore in terms of efficiency. Now suddenly they look like they're below average in terms of efficiency. Asia moved over a little bit too. So the allowance rate obviously didn't change, but now you see that the USA and Europe are actually pretty similar in terms of efficiency. It just didn't look like it because probably the USA, for whatever, cases were recently filed, for whatever companies, who knows, happened to be assigned to a group of examiners that work a little bit faster. So when you take that out of the equation, the picture looks very different. So if I were a law firm and I were having myself measured, as we see more and more firms doing, more and more corporations are requiring this, I would want to make sure that the metrics that we're providing are actually accurate. Okay. So up to this point, or actually, let me take a break here and take another poll question. So I asked you earlier about examiner statistics. How often are you using them in your workflow? So I also now want to hear from the audience how often you're using prosecution analytics to measure your own performance. And this is a little bit of a newer use case for prosecution analytics. The examiner statistics came out way earlier, but I will say that we're seeing uptake of this even more and even faster than we did see with the examiner analytics. So it looks like it's leveling out a little bit. And again, we're seeing a little bit, the majority is saying they don't use them yet, but up to almost 30% is saying they use them occasionally, and 7% it's now become a regular part of their job, which makes sense. This is a lot of what we see today in the industry. Now that these metrics are out there, it's almost, particularly corporations are feeling like they need to understand these metrics for their law firms, and law firms are finding that they can get a lot of value by sharing these metrics with their clients, marketing teams in particular. It's nice to be able to say something on your website besides being client focused. Now you can actually prove why you're objectively better than the guy down the street or not. All right, so I want to shift a little bit now to the second half of the presentation. So up to this point, I've talked about a lot of things that are fairly well known and that you can see from the polls are already getting into the industry. So, predicting prosecution outcomes using the examiner statistics and measuring the prosecution outcomes using a variety of metrics to understand how your law firm or corporation is performing with respect to others. But now I'm actually going to shift and I'm actually going to go into the Patent Advisor tool so that I can show you some more novel ways to use prosecution analytics to make your life easier, to make your work relationships more transparent, to make you better patent practitioners. So when we talk about prosecution analytics, a lot of people assume that I just mean numbers. And I can see how you would think that because I just spent the first 30 minutes of this presentation talking about that. But at LexisNexis, we actually do a lot of research into the substance of these patents and the substance of the office actions and responses that are issued. So specifically, recently, most of our energy has been focused on analyzing PTAB decisions. So ex parte appeal decisions in particular, those ones that actually have a decision document issued by the board. So what we did was we went through all of the PTAB decision documents issued since about 2017, and we categorized every single argument type, every single issue that can come up into this legal hierarchy that you see here. And it goes pretty deep. So probably most prosecution analytics providers that you've seen will tell you if a case had a 101, a 102, a 103 rejection, and we obviously do that too. But we realized that there was a need to go a lot deeper than that. So we built this hierarchy of legal arguments that you can see goes pretty deep into the weeds to help you identify for every single ex parte appeal decision what issues came up and whether the examiner was reversed, affirmed, or affirmed in part on that particular issue. So this is helpful, as you can imagine, in a variety of ways, but where we see it getting the most hold is simply with that very first decision that's probably the most important strategic decision you make during prosecution, which is, am I going to appeal or not? And of course, you can always look at the general appeal statistics. What are my chances of winning? But this lets you go a level deeper and say, all right, for my particular case and my particular situation, what are my chances of success? And moreover, maybe you already have a feeling that you need to appeal, but this helps you to justify that decision, particularly to clients who might be somewhat reluctant. So we'll say, for example, I found this examiner who has a lot of 101 rejections and a lot of appeals. So you can filter this, for example, to this examiner. If you got say you got a 101 rejection, first office action. You know already your chances of success are low because I'll tell you this examiner is in the 3690, which is a very unfavorable art unit for patent applicants. So you know you're likely to get a 101 rejection. And maybe you're thinking you want to position this case for appeal early on. So what this allows you to do is it allows you to see all of the PTAB decisions issued in cases involving this examiner. And what you see right away is that 50 of them were about a 101 issue, and of those, the examiner almost always wins. So I might filter this to 2019 just to see if things got better after the guidance was issued. And what I see is not really. And by the way, this is not filed in 2019. This is decisions issued after 2019. So right off the bat, I might look at this. You probably have a hard time advising the client to appeal under this situation, but maybe you're really convinced you have something to work with. You're convinced you've got to go to appeal. It's the only option. This is an important case. So that leads to the second reason that this data is so useful, which is finding that needle in the haystack, the winning argument. So 20% of the time, the examiner was actually reversed. Why did that happen? What did they say? How did this actually work? So you can dig in here and see what these reversals were based on. So it looks like every single one of these cases involved an abstract idea issue, and they both involved an analysis of step 1 and step 2. So I'll go ahead and look at all of these decisions to see if I can try and figure out what's going on. I'll limit it to cases where the examiner was reversed, right? I want to know when I can win. And maybe even I'm dealing with a particular issue. Let's say I'm dealing with an authentication issue and I want to see something that's technically on point. I may have cheated a little and known that one of these cases had an authentication issue. But what this brings me is a decision where this examiner was actually reversed on the 101 issue. So I can go right in here and I can read this decision, see what it was about, see what kind of arguments the applicant made, see the arguments that the examiner made in response, and what was it about the applicant's argument that was persuasive. And I will say, I think one of the most important things about this data set, most of the time people only look at appeal data, the statistics of the chances of winning, what the winning arguments were after they've already decided to appeal. But if I had one piece of advice from having spent 6 years looking at this data and working with people to implement this data to make their prosecution outcomes better, it's that more people should be considering appeals earlier in the process. We see it too many times that applications have gone through 10 office actions, 4 RCEs, and then they decide to appeal after the claims are kind of a mess and there's this huge prosecution record. And had they used the statistics to know that they had a difficult examiner from day one, that their chances of success were at least decent on appeal, they could have appealed earlier. And also getting the right arguments into the record early on, right? Don't wait until you're already writing your appeal brief to see which arguments are successful. Get them in your response to your first office action. It really, what this data does is it allows us as patent practitioners to do the same type of legal research that all other attorneys are already doing. So I started off my career very, very briefly as a litigator, right? And I wouldn't even dream of presenting a brief or a memo to anyone, not even a fellow associate, without having done some case law research. Who was the judge in this case? How do they typically respond? How does this type of argument typically fare in this jurisdiction? So I was really shocked when I moved over to the patent side of things, the patent prosecution specifically. Nobody did any kind of research. There's so few actual case law decisions, and it's frankly, I feel like a lot of times we don't know what to do with them until the USPTO issues guidance around them. We all know these decisions by heart. All I did, and I suspect what most people still do, is go on to my firm's SharePoint site, and grab an old office action response and mimic those arguments. So all I was grabbing from were successful arguments within my own firm, which is a really small database. Don't limit yourself. Now you can go on here and see successful arguments from the whole world of people who are filing patent applications at the USPTO. And specifically at this point, you can look at the PTAB cases, since those are theoretically more thoroughly vetted and hopefully more persuasive to an examiner, particularly if it was an appeal of their case. So we're continually updating this data. And so I highly recommend that you guys try out this new form of legal research that we're offering. All right, so the last thing that I wanted to talk about is how to incorporate the data in your workflow. So I think most people out there, after they see the data, they recognize its value, they want to use it, but it takes time. It's new. And so we want to make it as easy as possible to incorporate in your workflow so you can use it every single time. So what we did was we actually built a browser extension that sits on top of USPTO's public pair site. It also sits on top of the new data center, and it will, within the next month or so, sit on top of private pair. And what it effectively does is it gives pair a little bit of a facelift, but it also injects some of our most useful and most commonly used data points, so that while you're in the middle of your work, you're logging into pair, you're just going to file, you file a response. That data is right there in front of you. You don't have to log into a separate tool. So this is what pair looks like without the extension. This is what it looks like with the extension. It's super easy to add. All you have to do is click a couple buttons from the extension store. It adds it to Chrome. There it is. And then here's what it does. So now if I want to go to pair, which hopefully pair will work for me today, sometimes it doesn't. Pair is now converted into having patent advisor data. So right now, right off the bat, I'll know that this case is with a green examiner. Right at the outset, I can set expectations for this case. And you can turn it off if for whatever reason you ever don't want it. Obviously, we're Lexis with very, very high security standards. We are not using this to track your searches or anything like that. But if for whatever reason you don't want it anymore, you can always turn it off. But it's just something so that you always have in the background. Speaking of objections that we used to have that I don't really have anymore, but back when I started this, a lot of people said, well, knowing that the examiner is difficult or easy isn't really going to change what I do with this case. But I think years on the market of a product like this has proven that that's not true. If you know from day one that you've got an easy examiner, you're going to take a different tactic. Maybe even subconsciously, when you talk on the phone to the examiner, you may take a different tone of voice. And same if you know from day one that you're going into prosecution with a difficult examiner. It can help set the tone of prosecution from the beginning. And then, of course, this links you into Patent Advisor if you want to do deeper research. So maybe you want to look at the appeal statistics. Maybe you want to see what it looks like to interview this examiner. So this can bring you right into Patent Advisor and show you any of the more detailed statistics that you might need to make a particular decision on a particular day. So it looks like I finished a little bit early, But in conclusion, I just want to summarize what we've talked about. So first, we talked about, here, I'll pull this back up so that we can look at the summary. Okay. All right, so first we talked about how you can use the data to accurately predict what's going to happen in the future, and how to accurately kind of recap how you've done in the past. And we also talked about two just very tactical ways that you can use the data in your everyday life to help make better decisions, help set the expectations for other stakeholders around you. You know, I think at a very high level, just to sum up, our job as attorneys is to reduce risk. Right? We want everything to be as smooth as it can possibly be. And we're really lucky as patent practitioners because there's so much data out there that that's what it allows us to do. I bet litigators would kill to have some kind of data like this so that before they go into a big case, they could tell their client, well, you know, you have a 60% chance of winning with this judge on this subject matter. And indeed, we are working on products to do that at Lexis here as well. But we can do that and have been doing that for years on the patent side. So hopefully this presentation helps convince you that this data really, really can make your life easier, help with your work relationships, and make life easier for all of those around you who have to deal with the USPTO patent process. At this point,
Right, Megan, catch your breath there. I know we had some questions come in, so you can catch your breath and then kind of read through the questions too. I pulled out a few higher level ones that I thought we could get started with here.
Sure.
Lots of questions around the PTAB and the pair extension. Let's see, let's start with the PTAB since that's what you were just talking about a minute ago. What if the examiner in my case does not have any appeal decisions?
Yeah, that's a really good question. So for sure, that is one of the limitations of the PTAB data. We started there because they're nice, they're clean, they're well structured, and obviously they're the most reliable data set you can get to at the patent office, but it is a smaller data set. And you're right, some examiners simply won't have new PTAB decisions. So in that case, you can always fall back to the art unit. So just look at all the PTAB decisions in that particular art unit. We also have this time frame limited here. You could open up the time frame if you're dealing with a 102 or a 103 issue where the law isn't quite as dynamic. But in general, yeah, that's a good question. I would fall back to the art unit, which will almost certainly have a larger data set to work with.
Great, thanks for that tip.
And I see someone else along those lines asked if Patent Advisor classifies PTAB decisions by MPE section. We don't actually do that yet, but I do think that's a good idea, and something that we could work on doing for the future. To the extent that you know the MPEP, you could probably sync up some of these with some of the sections, and we could probably do that. But no, not yet. But thank you for the suggestion. Going through, are there any other questions that you saw, Allie, that you want to pull out?
Yeah, sure. While you're kind of reading through too, there was some questions around security. You did cover that a little bit, but in general around Patent Advisor, they're asking if you record searches or record searches in pair and how secure is it?
Yeah, we definitely do not record any of your searches. So it does use an API that sends data into Patent Advisor, so we know what data to return. Like we have to know which examiner you're looking at so we can send the right examiner data. But as soon as that API call is done, that data is erased. We are not tracking, what examiner you searched for. Nothing about the substance of your searches is going anywhere. That's all gone. And when you download the extension too, because Chrome is places security in very high regard. And I don't know if you can see it here, but when you download the extension, it'll tell you what website the extension is accessing. And our extension only accesses the pair sites, so public pair, the Patent Center. I see somebody had a question about that too. It does support the Patent Center as well. And then soon it'll support private pair. And Chrome will tell you that. You can't lie to Chrome. So Chrome will tell you we're only accessing those websites. We are definitely not saving the substance of any of your searches. But again, if you ever feel uncomfortable, you can always just turn this thing off. And then it's not making any calls to the patent advisor servers at all when you do this. So yeah, that was another question. It does support the new patent data center, and it'll have all the same data there that it has here. Somebody else asked, I think this is an interesting question. So going back to the notion of using this data to rank outside counsel performance, are corporations increasingly requiring their outside counsel to do this? Anecdotally, 100% yes, this is what I hear. I went to a women's panel back in, again, this must have been before coronavirus. Time is so strange to me now, but it must have been in 2019. And there were probably 200 women there from a variety of corporations and law firms. And my takeaway was that every big corporation there was doing something to provide measurements of their outside counsel. Either they were using some kind of data, or they were literally like spot checking applications for errors. Some of the smaller filers, less than 50 applications per year, were just starting to get on board with it. But they definitely recognized that they needed to do it because the larger ones are already in that game and have been doing that for some time now. Probably well before Patent Advisor helped with that, they were tracking these kinds of things. Let's see, is there a way to use this tool? So somebody asked, can we pull 101 approved claim language from historical data? We're not there yet to pull it directly for you, but you could absolutely get to it with this tool. Absolutely. So all I showed you right today was the PTAB decision search, because we have gone to such great lengths to identify every single legal issue that can come up during prosecution. But we do have fully searchable all of the image file wrappers. So for example, and actually I'll go in here. If you just wanted to do a search for claim language and applications that had been approved that had a 101 rejection, you could do that. So for example, if you want to look only at, if you want to look only at claims, we'll include office actions that have had a 101 rejection and that were approved. So where would that be? If you only wanted to look at patented cases, you could run that search. There's going to be a very big search, so I would suggest that you limit it somehow, maybe by art unit. We'll try 3689 or something like that. But absolutely, you can, and then this would pull up all of those claim sets and rejections that had the 101 rejection that were ultimately approved. So you could dig into the data yourself and find it. Let's see. Any other questions, Ali, that you want to surface as I read through some of them?
There was a question around ETA that came in saying that there are a variety of reasons that examiners might move faster or slower. How do you know this variability isn't just because of the variable novelty of each invention?
Yeah, and that's a really common question that we get a lot. So let me pull up here again. So this to me is the greatest justification for why I know that it doesn't just have to do with the substance. So for sure, the substance of the application is going to matter. If an application is very obviously not novel, I have full faith in the patent office to find the prior art that proves that and to knock it out. So I'm sure that happens. Also, examiner variability has a lot to do with two other factors. It has a lot to do with examiner experience. More experienced examiners tend to be faster moving. Less experienced ones are slower moving, and I'm sure there are very good institutional reasons for this. Also, technology. Some technology spaces are just tougher than others. But really, technology space just impacts the distribution of easy and difficult examiners. You'll find easy and difficult examiners in every technology space. The reason that I'm so convinced that the outcome is dependent purely on, just kind of examiner preferences and behavioral profiles is this analysis. So like I said, I've done this analysis for most major filers at the US, and every single time you do this, you break up their applications into two groups, one with the green examiners, one with the red examiners, and you always see very, very distinct differences in these two groups. Also, and this is just anecdotal, but if you've ever worked with a patent office, I'm sure you've come across examiners that have different attitudes towards patenting than other ones. So yeah, this is the most compelling analysis that you can do for almost any company or law firm. And you'll see, you know, the same technology, same lawyers, but very different outcomes depending on the examiner that you get. And then somebody else asked a question around the data source for this. It does all come from the USPTO. We have to do a pretty significant job of cleaning the data when it comes in. Some of the data is particularly difficult to get, like, for example, knowing who the law firm is on any individual application is one of the hardest things that we do. FAIR doesn't have a field that just says, here's the law firm at any given date and time. So we really have to go digging to figure out who that is and then clean that up because that data is raw. Same with the assignee of record. That data is just manually entered or typed and is full of typos and variations. So yes, it does come from public sources, but there's a lot of work that we do to compile it and make it actually useful and valuable to you. I think somebody else asked a question about whether ETA exists for particular technology spaces or whether it exists for CPC codes. Right now, we don't have CPC codes in the system, but what I will say is that you can search for any particular art unit, and what you'll see is, let's see, what you'll see is a distribution of the examiners. So let's hope I actually picked a valid art unit. Yeah. So what this tells you is the kind of the what I'll call the ETA distribution of examiners in that technology space. We neglected from creating a particular ETA for an entire art unit because, as you see, it really can be quite variable. Like this one, for example, has a lot of red examiners that might pull it up, but we also wanted to indicate that there's 3 green and 2 yellow. And then we also provide this lottery map, which is basically your chances of ending up with any particular type of examiner if you get an application assigned here. And this is interesting because so this is based on the number of disposals that every examiner type has every year, because basically if the examiner has an opening in their docket, theoretically you could get assigned a case to them. And because of the way they work, green examiners have very high docket turnover. And so even if there's very few green examiners in the art unit, you're actually like disproportionately likely to end up with one of them. So that's why we provide this metric as well. So no, we don't have an ETA metric at the technology space level, just because there is so much variability within the technology spaces. But we do give you an idea of what that variability and what that lottery looks like. All right, any other questions, Ali, that you wanted to surface?
Another one here while you're talking about ETA is if I get a patent from a green examiner, is it going to be less thoroughly vetted?
Right. Yeah. This is a really good question. I think that goes to quality. I think because I'm so far on the applicant side that I tend to make this judgment. Oh, green examiner is what you want because you want your patent to get through quickly. But a lot of times I've heard this objection, which is, well, don't you want your patent to actually be thoroughly vetted? You want there to be, enough examination. That same professor, Shine 2, actually did a study that gets at this, whether the more green examiners tend to issue patents that are later overturned in litigation or not. But what I can say is green examiners tend to disproportionately be experienced examiners. It's because they've been there so long, they're so familiar with the state of the prior art that they know exactly what patents are going to read on yours, and they know exactly what you need to do to overcome that prior art. And they're experts at working with you to get patentable subject matter out of that. So I don't think it correlates at all. I don't have hard statistics to prove that it doesn't. But in general, the green examiners are more experienced. So I actually think it's more likely that it's better vetted from one of those green, more experienced examiners. It just isn't going to have as long as a prosecution record, which is probably, it's depending on what court you go to and depending on what issue, that can be a good thing. Any other questions?
I'm trying to read through and see which ones you've already answered. So if yours has not been answered yet, and we miss it, I apologize, and we can make sure to follow up with people afterward.
Oh, and one quick thing, this is right now just for the US Patent Office. So all this data is US Patent Office data today.
As I scroll through, it looks like we've covered all the topics. So thank you very much, Megan, for your time, and thank you again to all of the attendees. And we will be sending out the recording as well as the link to the slides later today via email, so make sure you check your inbox. Thank you again, everyone.
Thank you, everyone. Bye.